Thank you, Ashton. Welcome, everyone. And thanks for coming. I'm Christopher Hoyer. I'm the acting director of the Research and Academic Program, and it is my pleasure to introduce Martha Buskirk. I'd just like to, first of all, thank you for coming and also thank all of the RAP staff and especially our new interns for making tonight possible. Again, I'm happy to introduce Martha Buskirk. Martha has taught art history and criticism at the Montserrat College of Art since 1994. In 2005 and again in 2013, she was a visiting professor at MIT. A scholar of the contemporary, Martha's scholarship focuses on contemporary art and its intersections with cultural production and society in general, looking into questions of objecthood, permanence, and appropriation in modern practice. She's written extensively on minimalism and pop, both during and after her time as a managing editor at October between 1990 and 1994. And many of you may know that there she edited a kind of now classic special issue devoted to Marcel Duchamp. Martha's first book, The Contingent Object of Contemporary Art, appeared in 2003. Many of you all may know it. And her more recent creative enterprise, Contemporary Art Between Museum and Marketplace, focused upon neoliberal museum culture's engagement with institutional critique. At the Clark, as we'll hear tonight, Martha has turned her attention to issues of artists' rights and intellectual property claims as part of a book project now in process on contemporary art and law. Professor Buskirk has been a fellow of the Henry Moore Institute and the John Simon Guggenheim Memorial Foundation, among others. And we're delighted to have her back for a second fellowship here at the Clark. She was here before. Her lecture tonight is entitled The Convenient Fiction of Authorship. Please join me in welcoming Martha Buskirk.
Okay. So thank you very much. Thank you to the Clark for having us all here. Thank you in particular to the research and academic programs and to Chris Hoyer, obviously, for that great introduction. Also, a special mention to Deb Fair, who's made our lives been so incredibly helpful to all of us, and to Rachel Burke, who has really been great in terms of helping me to track down some key images for this talk. So, as Chris mentioned, I'll be thinking about the interplay between art and copyright, and I'm going to introduce that through a few key examples, and then come at it in a talk that actually has three different sections that come at the issues from slightly different vantage points. So let me start with this vitrine at the end of a gallery showing the work of Jill Magid. And what you see here is a dramatically lit, but otherwise fairly conventional looking diamond ring. But before reaching the 2-carat gem, visitors would encounter a series of other cases of documents. And those documents reveal the striking origin of the diamond, including a certificate from the laboratory that created the stone from the ashes of the architect Louis Barragan, a contract between the Barragan family and the artist Jill Magid, and then a video of the exhumation in 2015 that allowed Magid the access to Barragan's remains. The 2016 exhibition was entitled The Proposal, and it's actually only one aspect of Magid's fascination with the rights and restrictions around the Barragan Foundation, around Barragan's life and work, which have arguably stood in the way of the full recognition of his austere but also sumptuous version of modernism. Following Barragan's death in 1988, his personal archives and library were left in the care of a friend who established a foundation that also oversees the Casa Barragan, which is what you're seeing here, in two interior views. His professional archive, however, was willed to his partner and then subsequently acquired by Rolf Feldbaum, head of the Vitra Furniture Company. Feldbaum established an alternate Barragan Foundation, spelled, as many people have complained, without the accent on the A, in 1996, And that alternate foundation is housed in Vitra headquarters in Switzerland. And it holds both the documents and also the assigned rights. The longtime rumor was that it was purchased by Feldbaum as an engagement present for his wife, Federica Zanco, an Italian architectural historian who has announced a planned catalogue raisonné based on the material, and at the same time has quite closely limited other people's access to it. Maggid's response to the somewhat arbitrary division of Barragan's legacy has been playfully provocative, weaving a narrative of her intrusion into what she has described and sort of imagined as a romance between Zanco and Barragan, and presenting objects and images that push up against the limits of the Swiss Foundation's copyright claims. So her proposal, the basis of the title of the show, was to give Zanco the diamond ring made from Barragan's ashes in exchange for the return of the archive to Mexico. So there's a double issue at play here. One is the potentially blocked access to research, which is no small matter, but the intellectual property claim is potentially more significant, since the Swiss Foundation claims ownership of, quote, complete rights to the name and oeuvre of Louis Barragan. Control is further ensured by their acquisition of photographs and associated rights for the official photographer of Barragan's architecture. But their ownership claim is actually even more encompassing than that, extending to all of Barragan's architecture, including this house, which is not only a public museum, but has been designated as a UNESCO World Heritage Site since 2004. So Maggid's diamond gesture was actually part of, for her, an extended flirtation with the interesting and not necessarily intuitive boundaries that frame what is allowed and forbidden under national copyright regimes. So here you have another earlier exhibition that she did from 2014, which also focused on the archival material, and this is one of the works, which involved physical copies of Barragan's books, which she altered by attaching a frame around one of the publication's already reproduced images. And so doing that, she was taking conscious advantage of the distinction under copyright law between making a copy and physically manipulating an extant copy that you own. And so it's a paradoxical limit that suggests one of the ways in which the readily available or familiar can also be, in a sense, off limits in various ways. So these objects also point to the issue of layered rights. They are a kind of collage, and in that sense are Maggid's work, but they also include at least two other authorship claims, Barragan's architecture and the photographer whose photograph is on the cover of this book. And so they draw attention to a series of crucial issues, including the interplay of authorship and ownership, tensions between public and private, and questions about cultural heritage and patrimony in the context of global trade and exchange. And it would really be quite difficult to overstate the role of intellectual property as both a central economic engine of our time and a vastly misunderstood force interwoven into the daily lives of anyone who participates in the contemporary media-saturated environment. What happens, for example, when an object on public display is captured within a still or moving image of its context? What if you take a photograph of someone's house with works of art on the walls? Some television shows play it safe by blurring any art that appears as part of interior views, and I thank Rachel very much for tracking down this response to my request of some television show that has blurred the artwork on the wall, so we get to see Keeping Up with the Kardashians. So what constitutes publication in an era of social media? Is there a meaningful distinction between commercial and non-commercial in an era when every click is potentially monetized? What if you had no plans to share your image with anyone, but you accidentally set the wrong privacy level for your cloud-based file? Even under analog regimes, the issues were already complex, and they have become infinitely more so in relationship to the weightlessness of digital transmission. Potential answers to these questions will also vary dramatically, depending on which country's laws you're consulting, even though many forms of transmission are unhindered by such boundaries. Copyright and related trademark claims concerning architecture are particularly striking for their potential impact on the interplay between physical and virtual in one's experience of daily life. There are, for example, tremendous inconsistencies from one country to another regarding what's known as freedom of panorama, generally understood as the right to record publicly situated art and architecture. Some countries, including Mexico, allow people to take and circulate images of copyrighted work as long as it's recorded from a public vantage point. Others allow photographs of potentially copyrighted architecture, but not of the nearby public art. In 2016, the Supreme Court in Sweden ruled against a Wikimedia site that was hosting crowdsourced photographs of Swedish public art, uploaded to a site where they were paired with maps and descriptions, which provided for a lot of people really dismaying evidence of how intellectual property claims can disrupt the interplay between the digital and the physical commons. So far, Egypt has not followed through on proposed legislation in the last decade to copyright the pyramids. But many building owners have turned to trademark law to establish their iconic edifices as brands. And there are certain claims that are highly specific. So, for example, the Eiffel Tower website tells you that if you take a picture of a photograph of the Eiffel Tower during daytime, it's public domain. But at night, they expect professional photographers, however that's defined, to get permission to capture the nighttime illumination. Nor is accessible public space as public as it might appear, given the extensive role played by privately owned public spaces, also known as POPs, in the contemporary urban development schemes. And sort of in an ironic footnote, the freedom of panorama in Mexico would not help much in relation to Barragan's architecture, because one of the things he's known for is creating striking interior environments with much more neutral exterior walls, as you see here with the Casa Barragan. Despite intellectual property's central role in modern economic developments, there is limited understanding and a great deal of misinformation about this ubiquitous form of what is essentially an intangible asset. Property that is, at its root, simply the right to copy. The already complex interplay of authorship and ownership, developed in response to analog modes of reproduction, have become infinitely extended by the financial stakes, pitfalls, and possibilities for loss of control induced by evolving modes of digital transmission. And then within the art world, there's the added complexity of increasingly rarefied conceptions of authorship, as well as a range of moral rights statutes that potentially extend an artist's long-term control over the disposition of work quite apart from the economic emphasis of copyright. So authorship is a central organizing principle, both for copyright and for art, but there are many reasons to describe it as a fiction. Although copyright's earliest articulation in the 1710 British Statute of Anne emphasized the prohibition against reprinting as a protection for authors, it was primarily at that time the booksellers who benefited. And once the right to exploit creative work is defined as a property that can be bought and sold, the originator, whose name is attached, may receive little economic benefit and potentially have limited control over its final form. And we can see in the music industry, as it developed over the course of the 20th century, plenty of examples of musicians who lost ownership over their musical output, and in some cases, ownership even over the name under which it was produced. In the art world, an attachment to the artist as singular source of a work persists regardless of practices that rely on huge studios filled with assistants, as well as extensive utilization of outside fabricators in the realization of what is also often generated in response to specific institutional invitations and requirements. And then, in the art world as well, the degree to which both authentication and even production can continue after an artist's death provides further evidence of how the framework of authorship depends on a shared consensus about the nature of an artist's work, rather than the isolated decisions of a single individual. Despite the fact that art making and intellectual property regimes can appear to operate at cross purposes, examining the two spheres in relation to one another can therefore help to illuminate important forces and tensions in both realms. So, everyone is an artist, according to the oft-quoted dictum of Joseph Beuys, well known for his inclusive conception of art making. Everyone is an author might be an appropriate extension for our own era, filled, according to frequent complaints, with far more people who aspire to be writers than readers. But in fact, everyone is an author in the eyes of widely shared copyright principles that articulate originality criteria separate from judgments of quality. And what could be wrong with an expansive attitude? Plenty, it happens, when we are talking about works that attempt to respond to the already extensive reservoir of the already encoded. So even before shifts from analog to digital, it was abundantly clear that efforts to engage with modern culture would necessarily include the landscape of commercial imagery, populated by a tangle of copyrighted and trademarked products. 1960s pop art, 1980s appropriation, as well as closely related developments in music sampling, remix, and mashups, all explicitly emphasize the reorientation of pre-existing cultural material. These practices also quickly came to embody the potential disparity between critical or cultural acceptance and legal understandings of authorship, with decidedly mixed results in US courts when the fair use exception to copyright was invoked as a defense. So current copyright scope actually has much more to do with corporate interests than with protecting the rights of individual creators, and particularly in this respect, the trend toward increasingly long duration, which is sometimes called the Mickey Mouse rule, based on the idea that Disney will succeed in pushing through additional copyright extension legislation anytime their rodent comes close to falling in the public domain. And in fact, as this nice little diagram that I copied from somebody's work shows us, this has held true so far. There's also the drag on critical engagement for a wide range of material, with Ava Boys, for example, widow of Joseph, notorious among curators and historians for her use of inherited copyright and moral rights prerogatives to insist on her vision of the work. During recent decades, this terrain has shifted in ways that range from subtle to dramatic. Appropriation is everywhere, widely practiced by artists, but also by anyone inclined to use readily available software and social media platforms to manipulate or simply repost existing material. Potential infringement is both impossible to suppress, but also much, much easier to discover via automated search functions. Artistic appropriation continues to offer an important theoretical framework for assessing the widespread urge to respond to pre-existing forms, but conceptual practices are also relevant, given that the versions of authorship based on collecting and archiving bear a striking resemblance to many popular web-based activities. Everyone is a curator would be even more appropriate as the new mantra for an era characterized not only by the blurring of job descriptions in the art world, but by the current popularization of that term, which I'm sure the curators hate, to describe just about any activity of assembly, arrangement, or presentation. So curating your shop window, for example. Despite art world acclaim for a now fairly long tradition of artists responding to well-known copyright and trademark protected imagery, courts have demonstrated a decidedly mixed view of this strategy. In cases involving appropriation-based work by Jeff Koons and Richard Prince, the U.S. Court of Appeals for the Second Circuit reached strikingly different conclusions in precedent-setting cases handed down in 1992 and then in a very different direction in 2013. The 1992 appeals court decision in Rogers v. Koons affirmed a lower court ruling that found substantial infringement in Koons's colorful string of puppies that you see here on the right, a sculpture that was based quite closely on the black and white, very small scale black and white greeting card that you see on the left by Art Rogers. And that prompted a lot of surprise and alarm because of the rather dramatic differences between the two in terms of scale, in terms of medium, in terms of the shifts of interpretation. By contrast, the 2013 ruling in Cariou v. Prince largely overturned a rather alarming lower court judgment of infringement, finding instead transformative use. And that term transformative is very important as a legal precedent. In the works on canvas that you see here, where Prince extensively incorporated elements of Patrick Cariou's photography. And here you see two of the documents from one of the court documents where they traced every single one of those uses for every single one of the works in contention. And what's interesting here, and if you are at all sort of curious about the details of the case, is that the appeals court found transformative use in 25 out of the 30 works and sent 5 of them back to the lower court for reconsideration. And so the one on the left, they found transformative, and the one on the right, they sent back to the lower court. So your guess is as good as anyone's about the distinction they were making there. But there's another interesting part of this case, which is an amicus brief that was filed in conjunction with the appeals process by the Warhol Foundation, which argued for an even more expansive understanding of transformative use. And their argument was that transformative should encompass transformations not only in appearance, but on the most basic level, changes in context. So attempting to achieve court recognition for a key theme of postmodernism. Now, ultimately, that remand was decided out of court, so there was no precedent set on that argument. But Prince seemed to not hesitate to act on that idea, because the next major body of work that he produced was this series of new portraits, which were taken quite directly, with really almost no change at all, from Instagram posts. So the only real change was the change of scale and obviously a change of context, seeing them in a gallery rather than seeing them on your device. Now, a number of works that he appropriated for this extended series came from a group of women that collectively call themselves the Suicide Girls, for a kind of conscious play with alluring self-presentation. And they responded with a kind of humor They didn't go to court. Instead, they went to the court of public opinion. They made their own large-scale printouts of the exact same Instagram material, just adding one additional line to it. And they sold theirs for $90 instead of $90,000, which they pointed out was a discount of 99.9%. And said that they would give all the profits that they realized from that to the Electronic Frontier Foundation. And yes, I do own one of these, not this one, a different image. I did get on there and get my $90 as opposed to $90,000 Richard Prince. And you know what? Richard Prince's work is really big in relation to a small everyday apartment. I hadn't really thought about that until I got it home. So they responded with humor. Donald Graham was not so amused. Donald Graham hired a lawyer and has filed a copyright complaint that's ongoing and might very well be another major decision in terms of how far a postmodern definition of authorship can be pushed in the courts. Now, in talking about this, it's important not to leave out a couple intervening steps, including a major 1994 Supreme Court finding of fair use in a case involving Two Live Crew's parody of Roy Orbison's Oh Pretty Woman, and then a case involving appropriation that Koons actually did win in 2006. But the outcome in Carriou v. Prince was nonetheless highly important as a significant and broad statement of fair use principles that does appear to encompass the kind of work that Jeff Koons was doing in his banality work. But there's another problem here, and that is that we live in a very international art world with both people and art moving across country boundaries on a regular basis. So when the work from the Banality Show was shown in Paris in the 2014 stop of the Koons retrospective, there was a new round of accusations of plagiarism. One of the sculptures that was accused of unauthorized copying wasn't actually on display because of damage that had been discovered when it was unpacked. But another one, the one that you see here, based on this NAF ad, was very quickly packed up and hustled out of the country as soon as there was a threat of a copyright lawsuit. But returning to the Prince issue around Graham's work, one thing that's really interesting to note here is that the Instagram image that Prince appropriated was actually not posted by Graham. It was posted by somebody completely unrelated to Graham, and you can see that it's actually a repost of somebody else who was completely unrelated to Graham, who posted it with no attribution. So it actually becomes a sort of interesting study of how the digital has facilitated this very intense circulation of image, sound, and text on social media and other platforms with little regard for origin or copyright. And for those of us who are old enough to remember mixtape cassettes that you would give to a friend, some people are too young for that, but some people I think remember it. It's perhaps a similar impulse, but a very different outcome between one object, one physical object handed off to another person, and the relatively frictionless exchange that would come about from music uploaded to a site like the now defunct Napster, where you would have the potential to reach an unquantifiable number of interested users with really minimal effort or expenditure by the person doing the uploading. In Koons's case, it took the publication of the String of Puppies sculpture on the front page of the Los Angeles Times Sunday calendar section to bring the work to the attention of Rogers. But corporations have made major investments in programs that will automatically scour the web, searching for infringement. And there are literally millions of takedown requests per day because of this software. There are also refinements to the software that examine material for infringement in the split-second delay between when you click and when the appearance of a post on your social media feed. And reading about that made me start to think, well, maybe we're not that far from a science fiction style extrapolation where the digital devices interwoven in our daily existence could be programmed to automatically blur out or silence anything in our physical surroundings that might be subject to copyright claims, preventing the material from even being recorded in the first place, much less worrying about trying to discourage further circulation. Now, sort of thinking about the larger picture here, Roland Barthes' Death of the Author essay, with its claim regarding the corresponding birth of the reader, was certainly widely cited in the context of postmodernism, but that makes me really wonder about what he might have had to say about today's dizzying recirculation of digital material as part of everyday practice. And caught in this flurry of takedown notices are multitudes of YouTube videos set to popular songs or incorporating appropriated imagery. Another piece of this is the incredible popularity of fan fiction. I mean, if you don't think it's popular, ask your students. It's popular. Emanating from a community of readers who express their response by writing sequels or variants. E.L. James' best-selling 50 Shades of Grey, has that ever been mentioned in a Clark lecture? Actually began its life as vampire-themed fan fiction, written in response to the Twilight series, and then in its defanged version, inspired its own legion of enthusiasts. And one reviewer actually suggested that some of those offshoots were substantially better realized than James's own sequel. While most authors and publishers have found it in their interest to embrace these communities of avid fans, J.K. Rowling and her publisher sued successfully to prevent a print version of the Harry Potter lexicon, which they tolerated in its web-based version. One commentator, arguing that the book should have been allowed under fair use, complained that, quote, giving Rowling what she wants would be like giving Egypt the power to control guides to the pyramids, presumably not realizing that Egypt had considered that very possibility. Then another part of this is that the acquisition of material by digital means is potentially far more contingent than owning a traditional physical copy, as Amazon Kindle owners discovered in 2009 when certain books began to disappear from their devices without warning, including, in a really amazing piece of irony, George Orwell's 1984. The doctrine of first sale, which is what allowed Magid to do as she wished with her copy of the Baragon book, has been extremely curtailed in relation to digital material, sharply limiting the possibility for any form of reselling of electronic downloads. And anyone who uses a public library will certainly have noticed the geographic constraints on ebooks, completely artificial on a form that could be transmitted wildly, which are generally quite closely tethered to specific municipalities by licensing agreements, in contrast to print copies, which can actually travel great distances in all their cumbersome glory via interlibrary loans, as the Clark Library is so wonderful about demonstrating to us. Users are likewise forbidden, under threat of prosecution based on the 1998 Digital Millennium Copyright Act, from circumventing digital locks and thereby exploring the inner workings of a lot of different kinds of computer-driven things that we own, ranging from the cars that we drive to medical devices planted in our bodies. Now, one reason for emphasizing art as a frame of reference to explore these larger concerns is the pervasive reach of contemporary practice. Because art of today now encompasses image and text, unique and replica, physical and virtual, aesthetic and political, as well as a myriad of forms of performance, sound, and moving image, art's making, but also its collection and its preservation, highlight some of the tensions that arise in these ongoing shifts from analog to digital. Not only that, but investigating points of tension can provide essential insight into art's ongoing cultural, social, and economic significance, as well as the broad impact of intellectual property regimes on cultural production. But in addition to that, the conflicts themselves highlight another crucial dynamic. One of the significant problems with this form of property, intellectual property or copyright, is the incredibly uneven playing field when it comes to protecting one's rights in the face of entities with deep pockets for lawyers' fees. So on some level, copyright is the right to hire a lawyer to defend your rights. Art is also an interesting case study for the many ways that authorship issues go well beyond the intellectual property purview, including basic questions about how the work as such is constituted and defined. And indeed, whether something is defined or described as art can be highly significant and potentially calculated. So if you have a building on the side of a mural that is, if you have an image on the side of a building that's a mural, it will qualify for a very different set of protections than if it's described as an advertisement. Or in one interesting case of this, just a specific example, this mobile clinic that the Atelier van Lieshout designed within a transport container. So it was a mobile clinic within a transport container that they designed for the abortion rights group Women on Waves. And the Dutch Transport Ministry demanded that the clinic be removed from the group's ship on the basis that they had violated the vessel's inspection certificate. But the group was actually able to solve the problem by providing documentation from the Joop van Lieshout that asserting the container's status as a work of art called aportable. So once it was a work of art, it was okay to have it on the boat. These very targeted and specific strategies correlate with Pierre Bourdieu's conception of fields of practice, all with their own rules and forms of knowledge, which are to some degrees autonomous, despite the many situations in which they overlap with one another. Within the field of law, Bourdieu has emphasized conflicts need to be reframed according to legal norms, and in the process, they are transformed into a debate between professional proxies. Thus, one aspect of bringing an argument to court is the requirement to completely retranslate the facts of the case to make them conform to legal rules and conventions. And I've been doing a lot of reading of those retranslations, and they can get pretty amusing at times. In part because of this need for translation, disputes that wind up in the court system also can bring to the surface unexamined assumptions, not only distinctions between art-related and legal expectations, but even distinctions within the specialized customs associated with different spheres of activity within the art world. And not surprisingly, given the scale of the present art market, many cases in the art law arena involve matters of authenticity, therefore encompassing status and authorship issues that potentially go beyond copyright and often into a different area of law called moral rights. Some of the most interesting conflicts involve problems that can arise when an artist defines a work contrary to a collector's interests or expectations. Thus, Katie Noland and Sotheby's were both sued when the owner of the work that you see here, Cowboys Milking, was dismayed by the fact that Nolan renounced the work due to damages. And so essentially the lawsuit was the owner trying to recoup the monetary loss associated with the artist's refutation and with the auction house's consequent decision to remove the work from sale. But given the right circumstances, even a claim of authorship can become contentious. Actor Alec Baldwin was outraged when he rather belatedly recognized that Mary Boone had satisfied his pursuit of an unavailable Ross Bleckner painting from 1996 by supplying him with another version of the same motif. So on the left, what he was after, on the right, what he got. So in both of these instances, the Noland and the Bleckner, the owners of the work took to the courts in response to the artists saying the opposite of what the owners thought they should say. Nolan asserting that the work in question was no longer the work, and Bleckner at least tacitly indicating that the painting purchased by Baldwin was the piece that Baldwin had been seeking. And then there's another little tidbit that came out of this, another declaration from Mary Boone herself, who said to Baldwin, "I am not an armadillo," responding to complaints about her thick-skinned willingness to pursue the sale. So Marcel Duchamp's once provocative ready-made gesture, enacting the transformation of an everyday object into art based on his declarative act, has been widely embraced and practiced as an artistic strategy over the course of the 20th and 21st centuries. But the status shift enacted by Nolan's performative statement happened more than 2 decades after the work's initial definition, when confronted with what a lot of people said was quite minor damage, she withdrew her authorship. In the case of the Bleckner, it definitely was painted by him, and in that sense was not in any way a fake, but perhaps a little bit more akin to the copies that you see in the 19th century, produced in response to this kind of desire. But there is the further question of whether Bleckner could declare the work's date by fiat. In other words, could he present something that was finished later under the date of the earlier painting? Both these conflicts bring to mind Michel Foucault's classic What is an Author essay, where he describes the author function, and bring that in the sense that there are other parties with a vested interest in the outcome who have contested the authority of the artist to interfere with a larger set of conventions regulating the definition of the work. In the case of Nolan, notorious for her reclusive withdrawal from the art world, one other thing that's equally striking is that her statement of withdrawal was actually made through her lawyer, speaking on her behalf and articulating her renunciation in completely legal terminology. So who gets to declare the status of a work? What can or cannot be framed or codified in legal terms? To what extent are the players in agreement about the rules of the game? So anyone can stand in their garage and declare their snow shovels a work of art, and anyone can declare themselves an art expert. And I probably didn't really need an illustration for this, but the Clark garage had these snow shovels just sitting there waiting for me. But the impact of a given declaration quite obviously depends on the relationship between the person making the statement and a whole series of values, assessments, and judgments understood and shared within the relevant field. While the power of the artist to declare or disown a work is in some circumstances legally established by moral rights statutes, procedures for how the work is defined as such in the first place and subsequent judgments of authenticity are also very deeply embedded in field-specific expectations and conventions. To the extent that a judgment of authenticity is believed, it also functions as a performative statement, with the potential to dramatically change the status of an object, including its monetary value and perceptions of it, without altering its physical presence. Legal judgments are also performative, constituting a situation where rendering a judgment presumably does make it so, unless, of course, the decision is overturned on appeal. While it might not be terribly dangerous to declare in a kind of rhetorical fashion, oh, that's not art, it can actually be quite risky to say that something is not the work of a particular artist, especially if that statement is made by an individual or entity with any form of presumed authority. Indeed, a number of estates and foundations have completely stopped authenticating work, specifically in order to avoid the threat of legal action from dissatisfied owners. And the once staid scholarly project of assembling a catalog raisonné has become equally fraught territory. Artists as well can get caught up in this web. And there are two really striking, even bizarre cases from this past summer that provide a kind of clue about the potential interplay between the court's power of assertion and that of the artist. So, Peter Doig, this past summer, was forced to defend his prerogative to say that he had never painted this canvas. The case brought in a Chicago court against the Scottish artist concerned a work painted in Canada during a time when Doig was living there as a teenager. The owner had purchased the work from an artistically inclined inmate with a similar name, but spelled with an E at the end, and later became convinced that he had managed to acquire the youthful work of an important and valued artist. And rather surprising to many, he was able to convince a federal judge in the district court system in Chicago to grant him a trial on his demand to have the work authenticated by court order and to require Doig to pay him $5 million in damages. So by comparison, a work for which Doig did claim authorship, shown in his 2008 Tate retrospective. In his authorship essay, Foucault speculated on the uneasy relationship between the author's proper name and the individual thus designated, conjecturing about what biographical information would or would not call authorship into question, as well as its relative importance in comparison to assessments of stylistic consistency. It was therefore striking when Doig's lawyers were compelled to argue that Doig was not, as the painting owner claimed, incarcerated at Thunder Bay Correctional Facility in his youth, having spent his teenage years in a different part of Canada, with the plaintiff countering that the supporting documentation proffered by the artist for that part of his life was insufficient to prove that he was not the person he said he was not. The court also heard testimony from Doig himself about his approach to painting, and while the owner ultimately lost the case, art world commentators were rather shocked that it had gotten so far, particularly given the possibility that a win, even if unconvincing to any knowledgeable collector, would have endorsed the premise that someone other than the artist could preempt the artist's authority to say what he or she had or had not painted. And what will become of the paintings presented as evidence in a South Korean case involving Lee Ufan's work? Around the same time that the Doig case was underway in Chicago, Lee was also in court addressing authenticity issues in the context of a criminal case brought against a gallery dealer charged with trafficking and forgeries. Experts had weighed in that the works were fake, And according to published reports, the suspect even confessed as much to police. But to everyone's great surprise, when Lee was called to testify, he examined the paintings in question and declared them genuine. So it remains to be seen whether the artist's statement will be sufficient to affirm the contested paintings as valuable examples of his work, when the artist's assertion of authorship is counter to both expert opinion and the alternative declaration purportedly made by the accused forger. Given the delegated production that is part of many aspects of contemporary practice, as well as the many proxies involved in the life of art over time, it is striking how tenaciously the system of individual authorship is maintained as an organizing principle in institutions, scholarship, and quite obviously the marketplace. In many cases, stratospheric valuations are clearly based on the desire to claim authorship of an authorized, in other words, branded work by a known artist, since otherwise there'd be little reason for the 99.9% price differential between the work of Richard Prince and the very similarly produced work by the Suicide Girls that I mentioned before. Copyright's artificial limits on multiplication and proliferation are a broad-based response to challenges posed by analog and digital modes of technical reproduction, but the art world has also developed its own procedures, often bound more by convention than actual law for articulating the boundaries of the work. The right to engage in the formalities of authorship is still tenaciously articulated as the prerogative of the individual artist, but disputes over how artists exercise these powers, as well as the extent to which certain aspects of the author function can be assumed by the artist's heirs or representatives, indicate underlying tensions and contradictions in this consensus-built edifice. So, final section by rights. Under copyright law, authorship is the basis for ownership over rights that can be readily bought and sold. But another body of law pertaining to moral rights, also described as personality rights, is specific to certain types of creative work only, and can actually act as a check on unfettered exchange. And this bundle of rights generally includes integrity protections, as well as provisions covering the artist's prerogative to claim and disclaim authorship. And these powers remain enforced even after a work has been sold. And so that was the authority on which Nolan's lawyer argued her right to withdraw authorship from her damaged work. The legal statutes protecting moral rights are founded on the premise that works of art embody cultural values that extend above and beyond their property status. Yet such codes also reflect a romantic conception of authorial privilege that stresses the artist's expression of personality through the creative process. During the 1960s and 70s, advocacy around artists' rights was tightly bound up with a larger wave of activism that included critiques of both art institutions and the market. Closely related developments in the context of conceptual art also emphasized legalistic definitions of the work. And these two threads converged in Robert Projansky and Seth Siegelov's 1971 Artist Reserved Rights Transfer and Sale Agreement. Hans Hake seems to be the only artist who has consistently used a version of it, but it still remains really notable for its articulation of resale royalties, as well as the ongoing control of the artist over aspects of exhibition and reproduction, even after the work is sold. Approaches to moral rights also vary quite significantly from country to country, with the US notable for a general resistance to providing this type of protection, which was enacted only in a very limited form in 1990 with a bill called the Visual Artists' Rights Act. Crucial distinctions from country to country include the degree to which moral rights continue after the artist's death, and whether they are treated as alienable versus inalienable including whether the artists are allowed to waive them. It also becomes clear that copyright and moral rights are functions that are much more intertwined than the official dichotomy suggests. So officially, copyrights are concerned with economic rights, moral rights are concerned with personality rights. But both artists and corporate entities use copyright as a form of leverage to block unwanted interpretation, and the right to assert or deny patrimony obviously has dramatic economic consequences. It's easy to be sympathetic to the idea that artists should have the final say when it comes to determining the integrity of their work, but it's also important to interrogate the degree to which authorial control coincides with the public interest in works of art. On the one hand, there is the understandable desire by artists to shape how their work can be employed, including resistance to its assimilation into commercial agendas, but granting artists the ability to control the context in which their work is exhibited or reproduced can result in the suppression of critical discourse. Therefore, these twin foundations, cultural significance and personality rights, do not necessarily function in tandem. The larger environment of copyright, as well as patent, by the way, protection, is equally riven by contradiction. Granting limited monopoly rights to creators is supposed to encourage invention, but overly long or expansive intellectual property regimes accomplish the opposite. It is important to remember that this highly artificial form of intangible property, the right under copyright, literally to make a copy, was not created just for the purpose of putting money into certain people's pockets, but for the greater cultural good, derived from providing such protections for innovative work. Likewise, even though moral rights are often described as personality rights, a key rationale for limiting absolute property rights is the protection of shared cultural heritage over and above the interests of any incidental owner. And it's easy enough to find moments of bad faith where authors or owners, artists included, demand absolute control over even forms that rely on creative activity by others, or derive their value from interest in assimilation in the culture at large. And so it's therefore crucial to link a broad and robust support for fair use within artistic production to an equally expansive understanding of its importance for the interpretive realms. It is also important to explore alternative models, and I haven't really talked about this, but Creative Commons initiatives provide a potentially much more flexible approach to layered authorship. A number of legal scholars have characterized the 20th and early 21st century expansion of intellectual property claims and limitations as a new enclosure movement, likening the transition from public domain to private property in cultural realms to the fencing off of physical commons. When authors or other intellectual property proprietors use legally conferred interest to shut down subsequent creative work or discourse, not only is the idea of a shared commons undermined, but the public is denied the potential benefit from a form of property that would not exist without constant reiteration as part of the larger social contract. So in conclusion, we are clearly in the midst of a profound transformation in our economic structures and our daily lives, linked to the developments of networked information and technologies. An examination of legal definitions of intellectual property can provide vital insights into changing art world dynamics surrounding the production and consumption of art, but just as significantly, issues relating to art can provide a crucial framework for looking outward to quickly evolving intellectual property developments. While I am not making an argument for the abolition of either copyrights or moral rights, I would certainly argue and promote a balanced approach that should include curtailing excessive duration, reducing inequalities based on access to legal support, and an expansive definition of fair use. Building off an examination of the current landscape, it is essential to advocate for the importance of a vital cultural commons. Thank you. Thank you very much. Yes, I'm happy to take a few questions. Okay, I see a question in the back. Mark.
Thank you, Martha. To what extent have you gone into the history of this? When do people start having to pay money to reproduce works of art?
To reproduce works of art is a little bit more recent than reproducing books. It's interesting how even into the 20th century, if you were trying to write a book about art, mostly the images were given to you. Now that, on the other side of it, there were artists who made their living from reproduction. So the Statute of Anne, which the first copyright statute, was very quickly followed by another statute that's referred to as the Hogarth Act. Which was giving printmakers the right to exploit their prints, but that was very, very narrowly defined to that form of reproductive art, as opposed to the idea of reproduction for critical purposes. So reproduction for critical purposes is really, it could have been supported potentially under legal strictures, but it really becomes a practice in the 20th century.
Do you know when in the 20th century? I mean, I know I'm thinking of a particular case, someone I work on, Ernst Ludwig Kirchner, who already around 1920 is saying, you have to have my permission to reproduce this, and it's an honorarium of so and so many marks.
I'd be curious to know about that, because what I've read, which is mostly anecdotal, is that really until mid-20th century, people were much freer about handing off reproductions.
Yeah. I also recall I was a curator in the 70s and early 80s, and we assumed when we lent out a work that we had the right to give permission to reproduce. And we learned at that time that when you own a work, you do not own the right to reproduce it. And one of the outfits, which no longer exists, Cosmo Press in Geneva, asked me as a condition for giving me permission to reproduce works in my dissertation that I, as a curator, would tip them off anytime somebody requested a loan, so they could follow up and demand a reproduction fee. But it was something that we were very unaware of, and it seemed to be more focused and more developed in Europe than in the United States. It was like totally novel to us.
Yeah, one thing that I do, a piece of the research I haven't really done, is to look at the history, for example, of ARS and VAGA, and obviously ARS is linked to artist activism of the 1970s. And so you have, on the one hand, very idealistic activism, and then on the other hand, this closing down of discourse that has to do with then these rights associations that, somehow, anytime we talk about copyright with art historians, the first question is about artists' rights in relation to publication, because that's where it's really hurt the art historians. But it hurts the discourse. It hurts the broader discourse, and not just about artworks being reproduced, about any kind of visual information being reproduced.
Hi, I'm wondering about kind of what happens to the physical art objects in all of these court cases. I'm thinking specifically of the Richard prints, where you said 25 out of the 30 were found to be transformative, but the other 5 were sent back down to the lower court. If they're found to be infringing upon copyright, like what happens to the physical works? Okay, well,
I maybe should clarify the case around those 5 was sent back. I'll give a sort of multi-part answer to your question. One of the ironies of these court cases is, and perhaps the reason why courts often don't find that things are substantially different, is they're looking at everything in photographs. So like they were looking at the Art Rogers photograph, and they were looking at a photograph of the Jeff Koons. and found, based on those photographs, that they were substantially similar. So the physical object doesn't tend to be paraded through the court system. Now, some of those decisions say, okay, as part of the infringement, you have to hand over the infringing material to the person who's just won. And so there was a separate side decision in the Art Rogers business where the Art Rogers could have wound up with the possession of a Jeff Koons work, potentially, but then there was some sort of side out-of-court settlement that where Jeff Koons got to keep his work. And based on the initial district court decision in the Prince v. Cariou, Prince would have had to hand over the physical objects that he still owned to Cariou. And it didn't happen because they immediately appealed, and then on the appeal, Prince won. But it could have been in Cariou's, up to Cariou what he wanted to do with those objects. And one thing that I haven't read about deeply, but certainly around authentication issues, in France, if something is found to be not authentic, it can potentially be destroyed. And so there are actually cases where people try to keep the object out of France, even if the discussion about its authenticity is taking place within France, just in case something goes against them. So yes, but yes, what happens to the object, and what happens to the object, in a sense, what happens to the object whose status has changed is also interesting.
I have a long and distressing experience photographing things and trying to get permission to photograph them. And then when I get permission to photograph them, permission to use the photographs. And it's clear that all of the rules and regulations, well, there aren't any. They're just a series of interpretations and a hopeless tangle about many things. And I've stood on streets arguing with homeowners that I have a right to photograph their house from a public street. They say they don't. The cop standing next to me says I have a right to photograph it, which was scarcely a courtroom, but it's a complete mess. Are you in any way optimistic that someday sanity will prevail, or will it forever be like the U.S. tax code?
It has gotten so insane that there are some pushes toward greater sanity. Like the CAA did a code of best practices, which is, I think, somewhat flawed in terms of not pushing hard enough on the issues, but it is at least giving some ammunition for what should be a fair use case to be made. There is a very strong argument that all the uses that all of the people in this room make of images in their writing, except maybe the one that's on the cover of the book, that's more advertisement than actual critical discussion, should fall under fair use. And some publishers are getting a little bit bolder about asserting that. Of course, then you once again have the nationality problem. Your publisher is publishing the book in the US under fair use laws, but then they may also have a London office. So you have a whole other set of problems. But no, I don't think it's going to get more sane. I think we are looking at crazy layered rights. Just, a kind of palimpsest of one right on top of another right on top of another right on top of another right. And certainly even knowing about this, in my own work, I've made some sort of arbitrary decisions about how far down the chain does one actually even want to ask. Like, should one, knowing that Elaine Sturtevant's Warhol Flowers was based on Warhol's flowers, which was based on a photographer's flowers, would you want to ask the Warhol Foundation? Would you want to ask the photographer? No. Let's just remain blissfully ignorant until somebody calls you on it.
Thanks for the talk. It was really fascinating. And to push maybe further into the confusing palimpsest and hopefully not off a cliff, I just was wondering if you were aware of any current debate or discourse around the use of copyright and this transformative use concept as applied to virtual reality or augmented reality. I'm especially thinking of augmented reality here because it sort of is a departure from VR in the sense that it uses, the available world as well as a kind of fictionalized add-on, a transformative property kind of applied to something out there in physical space. And I just am wondering about augmented reality, if anyone needs like some mooring right now, is kind of most popularly demonstrated in the Pokemon Go app, which is very popular right now. So I'm just thinking about like a situation in which the copyrighted image of the Eiffel Tower at night or something, like in an AR, an augmented reality sort of app, is suddenly made invisible or blurred in the Kardashian, way. Are you, yeah.
I mean, the current climate is dizzying. I mean, when you actually look at, Cornell University has a great website about listing of key copyright cases. And then, there's like one here, one there, and then just in the last decade or so, there's just so many because of the very issues that you're thinking about. I haven't looked at that specifically. I have been thinking about Google and the way in which Google Street View it gives us a worldview that a lot of artists have been using, and is Google's Street View sufficiently original to constitute a copyright on their part? Because actually nobody has seen most of those images until people start using it. They were just seen by machines, by the program that acquires the material. So, I mean, yeah, if you have a Pokemon Go figure, are you allowed to see the Eiffel Tower behind it? Another example, which I haven't spent a lot of time with, is the Google Museum. Has anyone played around in those Google Museum views? And you sort of virtually walk around the room, and half the work, at least the last time I did it, was blurred out because clearly they hadn't cleared copyright for, or didn't know if they needed to clear copyright for half the work in the room. So, your physical experience of that room was very different than your physical experience would be very different than your virtual experience, even if they're trying to be very similar. So, I mean, if you want to talk to me about augmented reality, I'd love to talk about it, because I have to say, I'm not a big tech person. I read about tech more than I play in tech. So, I sort of read about cases that involve augmented reality, read about cases that take us into this crazy realm of virtual realms, rather than being a person who's a real denizen of those realms myself. Yeah.
Thanks for the wonderful talk. Even as you point to the kind of paradigmatic postmodern references of Barthes and Foucault, the concept that I thought of as you were speaking was Du Bois' concept of the spectacle as, the image as capital, right? Or that it's the moment where the image coalesces into capital. And I mean, in some ways, as I'm thinking through all the examples, another kind of term that I think is of that world of technology is the monetization, right? That somehow these are moments when the image becomes monetized. Because I think we can all think of moments when there are these creative borrowings and appropriations that don't reach this litigious stage, and it's because somehow the question of monetization has not reached a critical point. And so I'm just, I'm thinking about how much does this have to do with monetization? Is there a way to, and maybe as a corollary, I mean, does that make art that doesn't deal with this somehow irrelevant, or art that deals with this, is it complicit? You know, I mean, is it all about monetization, or is it, I mean, how much is it about creativity and expression, really?
Well, I mean, the monetization is huge, partly because it has become so broad-based that, that you can get small amounts of money for clicks based on how you set up your website, how you set up your different Instagram feeds, so that there are ways in which the monetization possibility has become pervasive. And so, as soon as we start to scrape away from this idea of social media and sharing, then you get to social media and monetization. So that has gotten very intense. Ideally, artists would not have to think about that in their studio. It could maybe, the studio would be a place to get away from some of those questions. But as soon as the work sort of is part of the larger world, then those issues of ownership become really pervasive. And I certainly one of the places that another interesting sort of side thread is, do you own your own biography? And there are lawsuits that have to do with fiction based on somebody's life story, and are you the proprietor of your own biography? And what's interesting, and I think one of the really scary parts of this, is how much all of these questions then come back to the money. So it's not even so much the idea of control, it's the idea of ownership, and then ownership with the next part. Okay, if it can be owned, then it can be sold. Maybe one more question, and or maybe we'll call it a night.
Well, thank you.